Joseph Mwangi Njeri, you've been charged with conspiracy to defraud, contrary to section 317 of the Penal Code. Oh, okay. Kiswahili.
Kiswahili.
Sawa sawa. Joseph Mwangi Njeri umeshtakiwa na kosa la kupanga.
Mr. Mwangi.
Yeah.
Uko na hasira?
Hapana. Sio hasira ninayo. Ni style tu ya kusimama. Ama nikae hivi. Niko very keen nasikiza mashtaka.
Okay, basi endelea kusikiza.
Okay.
Joseph Mwangi Njeri umeshtakiwa na kosa la kupanga njama ya ulaghai kinyume na kifungu cha 317 sheria za jinai. Maelezo ni kama yafuatayo: katika tarehe isiyojulikana na mahali pasipojulikana katika Jamhuri ya Kenya ukiwa na mwingine ambaye yuko kotini, nilipanga njama ya kumlaghai Agnes Kagure Kariuki kutoka uwanja ambao ni umesajiliwa kwa nambari LR 209 484310 ambao ni nambari ya IR 15372 ambayo ina uzani wa takriban 0.3252 ambayo iko katika barabara ya Jogoo, ambayo ni pesa milioni 200, kisa ambacho ulikuwa unajua ni cha uongo. Joseph Mwangi, kama si kweli?
Nakataa.
Katika shtaka la pili, umeshtakiwa na kutengeneza hati ya uongo kinyume na kifungu cha 347 sheria za jinai. Maelezo ni kama yafuatayo: katika tarehe isiyojulikana katika Jamhuri ya Kenya ulitengeneza hati ya uongo ambayo ni kitambulisho ambacho kimesajiliwa kwa nambari ya serial 230624436 ambayo iko kwa jina la Francis Kimani Mungai. Nambari ya kitambulisho ni 0979675, ukidai kwamba ilikuwa ni hati halisi kutoka idara ya usajili wa watu, kisa ambacho ulikuwa unajua ni cha uongo. Ni kweli ama si kweli?
Nimenakili ya kwamba umekana kila moja ya haya mashtaka mawili na utapewa taarifa ya washahidi wa kwanza mashtaka pamoja na stakabadhi zitakazotumika kama ushahidi dhidi yako.
As I apply for bail terms, I want to bring to the attention of the court that the co-accused was charged on the 10th of this month in criminal case number E587 of 2025.
Criminal case number
E587 of 2025. It's a court 8 matter which is coming up for pre-trial on the 8th of December 2025 before court number 8. And her name is Milimani, and she was released on cash bill of 100,000 shillings with 2 sureties of similar amounts. Your Honor, although the figures appearing on the charge sheet.
So you want me to decide the bail issue?
Yes, I wanted it because it's similar offense. Same, there are 2 co-accused. At most to have the same bail terms and to have the matter mentioned before the said court so that they can be consolidated. You know, these 2 parties are plaintiffs in an ELC case number 345 of 2018, they were due to testify yesterday against the claimant, and he was actually arrested when he was waiting for the first witness to finish the examination. To us, it's a matter that is to force them to withdraw in respect of the same subject. So we are praying that the same terms be maintained. He's 65 years old and diabetic.
So plea was taken and the matter is allocated already to court number 8?
Yes, it was taken on the 10th of November. We were given a date for pre-trial on the 8th of December.
In view of the indication that the matter is related to another one already before court number 8, the matter is mentioned before court number 8, it's a consolidation on Monday this month. Bail and contract will be determined by the trial court on the nation.
Yeah, I don't know if he has to go back to the police or...
Yes, he will be in custody until
Your Honor, before you pen off, the accused medical, we were asking for an interim cash bail. We can release him even on a cash bail of 100,000, pending arraignment on a Monday, because of the accused medical condition. He has ulcers, and then also considering his age of 65 years. And we want prerogative of mercy. Sorry? No, if you can cash bill, then to come for me.
What I see determined by the trial court on Monday. I have no way of verifying here, but the term stipulation
I have the documentations from the court.
Please sit down.
I have the documentation that will assist the court.
Next, tumemalizia. Tafadhali uniwekee pressure.
Criminal case number E613 of 2025, Bibros Kwamboka.
Habari yako? Unaelewa Kiswahili?
Bibros Kwamboka umeshtakiwa na kosa la shambulio na kusababisha majeraha ya kimwili kinyume na kifungu cha 251 sheria za jinai. Maelezo ya mashtaka ni kama ifuatayo. Mnamo tarehe 14 mwezi wa Oktoba mwaka 2025 katika eneo la stage ya Naivas ambayo iko kata ya Nairobi, kinyume na sheria ulimshambulia Phyllis Wanjiko Muhia na ukasababisha majeraha ya kimwili. Ni kweli ama si kweli?
Si kweli.
Damu unaishi wapi? Nyumba yako ama nyumba ya kukodesha? Unalipa rent pesa ngapi?
27.
Wewe na mlalamishi mnajuana? Plea of not guilty is innocent. The defense will supply the copies of witness statements and documentary evidence. The accused is granted cash bail of shillings 10,000 with one contact person. The case is allocated to court number 6. Retrial mentioned before court number 6 on 3rd of December this year.
Criminal case number E615 of 2025, Frida Wangari Munene.
Good afternoon.
Good afternoon.
In that matter, my name is Amina. Coding brief for Mr. Tayo.
Mr.
Jogota. Coding brief for Mr. Tayo. Coming on record for that.
Madam, do you understand?
Swahili.
You don't understand English at all?
I do not respond in Swahili.
Okay.
Okay. Do I use English or Kiswahili?
Yes?
I use English.
Yeah, you can use English, but I respond in Kiswahili.
Okay. Frida Wangari Munene umeshtakiwa kwa kupokea pesa kwa visingizio vya uongo kinyume na kifungu cha 313 sheria za jinai. Maelezo ya mashtaka ni kama ifuatayo. Katika tarehe mbalimbali katikati ya tarehe 15 mwezi wa Januari mwaka 2024 na tarehe 15 mwezi wa Machi mwaka 2024 katika kata ya Nairobi ukiwa na nia ya ulaghai. Ulipokea pesa kutoka Muslim Adano Wato, pesa taslim 640,040 ukijifanya kwamba ulikuwa na uwezo wa kumweka katika biashara ya kutakata tena ama recycling plastiki, kisa ambacho ulikuwa unajua ni cha uongo. Ni kweli ama si kweli?
Siona. Before we can plead to the charges, I would like to be guided by this code. Pursuant to section 89, subsection 5 of the Criminal Procedure Code, in relation to the legality of the charge sheet and the particulars that have been read to this court this afternoon. Your Honor, what I have gathered, she received money from the complainant known as Muslim Adano Wato, and the way she received that money is because they had a loan agreement, which there's a copy in the police file, and also I have a copy of statement showing how she has been making the attempts to pay the same amount. So, based on that, I am of the opinion that this is a purely civil matter, which should be adjudicated in another forum, but not on a criminal aspect. So I'm inviting the court to make a determination on that before she can plead the charges. I have the agreement with me, and I have the statement with me on how she has been making that payment. Until the time she got it, then she was unable to pay. Yes, Lord.
Is that a question of fact or a question of law?
It's a question of what fact, I believe so.
Section 89.5, do we deal with questions of fact or not? Whether the charge sheet discloses an offense or not?
Absolutely.
So we duly look at the statement of charge and the particulars and see if the two go together. If they don't, we apply 89.5. If they do, which is the case here, we wait for issues of evidence to come out during trial.
Very well.
Yes.
Thank you.
You're welcome. Can you remember where we stopped? We start all over again. Do you remember what he read to you?
Yes, I can remember.
Is it true or not true?
Not true.
On the second count, we've been charged with obtaining money by false pretenses, contrary to section 313 of the Penal Code. Particulars of the offense are as follows. On diverse dates between the 15th of January 2024 and the 15th of March 2024 at Nairobi Central Business District within Nairobi County, with intent to defraud, obtained from Hadija Adan Wato a sum of Kenya shillings 800,000 by falsely pretending that you're in a position to incorporate her into a plastic recycling business, a fact you knew to be false. Is this true or not true?
Plea was not guilty. He sentenced on each of the two counts, and the defense being supplied with copies of witness statements and documentary evidence. Do you have any issue with that?
Yes, Your Honor. I'm requesting that the accused person be admitted on the good of Washington terms. And the reason why I'm asking for the same is because she's a single parent with a minor. 200% depends on her. And she is not a flight risk. Her place of residence is known. Yesterday when we were recording the statement with the investigating officer, she disclosed her location. It is in the statement. And again, even some of her family members are present in court. So that in case you need a surety, then they can guarantee her tenants in court. Again, Your Honor, my client has been undergoing two very terrible business movements and imposing high cash bail terms may not be practically possible to raise, even after speaking with the entire family. And again, Your Honor, if she is given reasonable cash bail terms, then she'll be able to secure her release, and within that period when she is out, she'll be able to run her business so that she can raise the amount that is in question in this particular amount. So we plead with the court. We have no possible cash bail terms. We can even work with the nominal being 10,000 cash bail, or maybe we have court terms. And one more thing, Your Honor, before I forget, depending on how the outcome will be, my client is of ill health. She's asthmatic, and she has an issue in her knees. So when the court is giving it his orders, they should factor in that she be taken for medical care.
Ask the court to consider that this person is facing 2 counts. And the amounts involved and the main basis for granting an appeal paid in 1 terms to ensure that the come to court. That's all.
The accused is granted bond of 700,000 in one surety. She got a cash bill of 300,000 shillings with one contract person. The case is allocated to court number 7. Retrial mentioned before court number 7 on 3rd of December. Is that okay?
Your Honor, you respect the decision of the cash bill.
I'm asking you about the date.
Oh, the date is okay.
Yes.
I have one thing to comment, not about the cash bill. There's a document that was taken from us, the investigating officer. That is the agreement, the loan agreement. We'd like to get an order from this court. We have the same being given back to us. It was forcefully taken. There's a loan agreement between the accused person and the defendants.
Unless I ask the IO, I am not privy to anything. I wasn't present.
I do understand.
I don't know whether it's present.
His name must be Saimimo.
Like, is a name here?
Or in the alternative, we have to come in on that so that he can give us that document. It is very important for us. So I'm praying that we have that in my order from this court.
Okay. Why don't you wait for him to disclose to you whatever he's going to use as evidence, and then you're able to tell whether it is an exhibit or not, and then thereafter you are able to move the trial court.
This was our document.
Or it has to be your way, the way you want it.
Sorry?
Or it has to be your way.
No, it is not supposed to be my way.
If you reflect on what I'm saying, you realize it makes a lot of sense.
That is not a way.
If it is not part of the evidence intended to be relied on, then you can move the trial court accordingly.
Thank you so much.